just kick off in the interest of time.
Yeah.
So I'm kicking off. Let me just go live in a minute now. So hello and welcome to Conversations with Esther tonight, the 27th of August, 2025. We have an amazing guest, Peter, in the house. Allow me to just present something here as we move on. Just make this presentation and then we move on. Just a minute. Good. So good. I hope you can see my slides. Karibuni sana. Allow me to pray. As we begin, Father, we thank you for this session. We pray that you will lead us and guide us and instruct us as we learn in Jesus' name. Amen. So welcome to our fireside chats tonight as we continue. Allow me to introduce Conversations with Esther for those that may be joining us for the very first time, very quickly. Conversations with Esther is an impact-driven professional platform that informs, educates, and rebuilds mindsets on work, organizational culture, and holistic wellness. Now, we ignite ethical leadership and authentic leadership, promoting best practice within industries. Now, Conversations with Esther equips the workplace with relevant legal, human resource, and holistic wellness skills through training, motivational talks, end-to-end HR consultancy, support, and mentorship programs. Now, we are guided by our three values: integrity, excellence, and impact. And we envision a workplace transformed by professional conversations, respectable relationships, and intentional leadership. We speak broadly on your wellness, your holistic wellness, and we remind you every time we gather that your wellness is your absolute responsibility. Now, we talk to you on a physical, mental, financial, social, spiritual, environmental, and intellectual wellness. Now, which of these pillars are you excelling in? Is it your physical wellness, your mental? I have seen Becky in the room, and I've been seeing her posts of physical wellness. Congratulations. And she also told me that today she took herself out. That is also important for your mental wellness. Becky, congratulations. So let's begin on issues around wellness. Now, this is our calendar for the year. I am moving pretty fast. We are at 30th of August, we have an event branded Facing Our Fears, Daring Activities. Now, I will share this on the link on the chat, so no worries. Now, this is the event that's coming up this Saturday. I know we have people that have already registered. So for those around the call and have not registered, we have an amazing event, a time to breathe. Facing Our Fears, Daring Activities. We have zip lines, sky bikes, archery, high rope, scary bridge, swimming, and all that. Now, the cost is only 3,500. That cost will cover 2 activities of your choice, your lunch, and 2-way transport from CBD. Now, the venue is at Sitam Kadolta, that is Kiserian. Ever heard of exposure therapy? Exposure therapy is a psychological treatment that was developed to help people confront their fears. When people are fearful of something, they tend to avoid the feared objects and activities or situations. To help break the pattern of avoidance and fear, a psychologist may recommend exposure therapy by creating a safe environment in which to expose individuals to things they fear and avoid. Now, the exposure therapy, the exposure to the feared objects, activities, or situations in a safe environment helps reduce fear and decrease avoidance. Now you know. So facing our fears, daring activities this Saturday, book your spot. We will share this in the chat as we go on with the session today. Sorry. Good. You must have heard of the Zamara Summit that is upcoming. I'm glad we have Jay in the room, and I know he's attending. We have Becky. I know she's attending. I don't know who else on the call is attending. You can just put your hand up and say, I'm attending. I will be attending as well. The Regional HR Summit, Fit for Future, Redefining Work, Workplaces and Talent. That is on 3rd to 5th of September 2025 at the Diamonds Leisure Beach and Golf Resort. Now, is Elijah in the room? Elijah of Zamara. Are you in the room? Good. I think we'll look, I know he'll be joining. We'll give him time later. And we will share that link with you. Some good news here. Thank you for your support. When we win, we win together. So just to make this announcement that officially I am joining Christ University as the outreach and admissions advisor. Now, Christ University is based in India with different campuses we are connecting Africa to Christ University. So if you need to study abroad, let's talk, let's have a conversation. So good, this is our session tonight. It's an open mic show. Now, open mic, we mean we will allow you to ask your questions and the wakili in the house will answer. Now, the workplace can pose significant challenges and risks resulting from the employee life cycle management process. That is talent attraction all the way to separation. Now, tonight we engage in a candid conversation aimed at helping you avoid legal pitfalls while saving the business unnecessary legal costs. Now, we have Wakili Peter Kinyanjui, a very good friend of mine. I have worked closely with Wakili. We happen to be Wakilis, the two of us. So we have worked on projects closely. And I can tell you we have the right person in the room. Now, Peter is an advocate of the High Court of Kenya, HR practitioner and certified data protection officer with over 15 years of experience. Now, Peter, karibu sana. I want to stop sharing. Karibu sana. To the session, I see my fellow Wakili also, the law in HR, Kavo in the room. So we have the right people in the room. We are 62. So what we are going to do tonight is to unmute and ask our questions. But before then, I know Peter can give us a brief on the Employment Act and what is expected, and then we can jump into the questions. We will try and answer as many questions as possible tonight. So I will ask the law in HR and I'll ask JCVs to keep an eye on the chat and we will coordinate on the chat together. Karibu sana, Peter.
Thank you, Esther. Yeah, thank you for having me in this conversation. Apologies as those who might have joined earlier noted we were having some technical issues, apparently, which we're trying to sort on the video. But in the interest of time, I think it's good that we proceed. So, as introduced, my name is Peter Kinyanjui, a practitioner in both law and human resources, and a certified data protection officer. And in honoring this invite, I was basically told that it's going to be an open forum where we can be able to ask diverse questions on the field of employment law. And therefore, Esther, I'd be keen to be guided because, you know, this employment law is quite wide, with quite a wide spectrum of statutes that guides employment law, starting with the Constitution of Kenya. We have the Employment Act, we have the labor relations, we have the labor institutions, we have even now emerging statutes still that are trained on employment, to be the Data Protection Act, new emerging areas of human rights and how we treat employees at the workplace. So it is quite a wide spectrum. So I do not know how you guys will proceed, but I should be able to take it from whichever angle it is brought. But perhaps, unless you want me to, first of all, ventilate on a certain aspect of employment law.
Yes, thank you. Thank you, Peter. I know we will. Please, I see we are 64 in the room. That could possibly be 64 questions. But I want to begin this as the rest of the people, those who are not able to speak, to unmute, can type in. But those who will be able to speak, please raise your hand so that we can spot you faster. But I want to ask you, Peter, I have, being in HR, I have seen a lot of, and I get a lot of calls from people on contracts, you know, on the type of contracts that we should give, you know. That area is a very sensitive area because that's the entry point for any employee. Now, there are people that may not get contracts, and because they are paid for a year or so, the issues come up when we have to separate with people who do not have contracts. I'm beginning there because that is the entry point. I will pick it from contract and we go into performance management. That's another very tricky space because we have issues. I am currently handling cases of people that on a PIP but have no job descriptions and have not gone through any performance conversations. So talk to us about contracts to start with. What type of contracts do we have, and how should we handle contracts, especially when it comes to terminating the contracts? Then we can move that way.
Fair enough. Widely, we have got, okay, before I go to the main contract, types of contracts as it were, perhaps it is important to first of all spell out the provisions of the law that provides that every employee must be issued with a contract of employment, which is written within a period of 3 months from the date they are engaged. But that notwithstanding, the law recognizes contracts of employment that is written. It also does recognize a contract of employment that is oral, and even recognizes a contract that could be implied from the behavior of the parties therein. So to begin with, you have a duty as an employer to ensure that a contract of employment is codified in writing within a period of 3 months. But even if you don't do that, it does not mean that the employee is at disadvantage, because the courts can imply contracts from either, even if it is not documented, maybe oral or even implied. But the major types of contracts envisaged under the Employment Act would be casual, and a casual contract would be one that is valid for 24 hours at a time. And here the assumption is that there is no duty or there is no expectation that the following day an employee would come to work. So it renews and lapses every 24 hours. Now, and as you note, these are supposed to take care of short-term labor needs. And if overused, then that becomes an unfair labor practice under the Constitution of Kenya, and especially where you're using casual labor on work that is otherwise of permanent nature. And according to the Employment Act, if it is work that may not be completed within a period of 3 months, then ideally then that mode of contract would be abused if it is the one prevalently used. Having said that, the next type of a contract would be the fixed term contract. And this is a contract that would have a definite beginning and a definite end. And this could be anything between a contract of a week, 2 weeks, could go to 1 year, 2 years, 5 years, provided that the contract of employment has an expiry or a lapse date. This is what is usually encouraged since they ensure that the employees are able to enjoy all the benefits that are envisaged under the Employment Act, be it the weekly off days, be it the statutory deductions, be it the sick offs, be it the annual leave, even if it is on short term, then you're able to prorate. And in essence, an employee who is on a term contract benefits from all the, is able to benefit from all the provisions envisaged under the Employment Act. And of course, the last one is the one that sometimes referred to permanent, but we call it open-ended. And what distinguishes it from a fixed-term contract is that it does not have an expiry date, and therefore it keeps on as long as there is work, as long as the employee is performing, and as long as the employee is disciplined. Now, for both fixed term and permanent contract, they are all terminable by at least a minimum, and here I'm saying a minimum of 30 days, because parties could contract for a longer termination notice. And if it is shorter than a month, then the period of payment or the cycle of payment is taken to be the notice period of termination should either party wish to terminate that contract of employment. But then also in a nutshell, just to say that if you need to terminate that either fixed term or a permanent contract, then you do need reasons. And the reasons, according to the law, Section 41, those reasons would have to be either performance, discipline, or physical ability. There are only those 3 grounds widely under Section 41. That is discipline, that is performance, and physical inability or incapacity. Those are 3 grounds that you can terminate. But beyond or outside Article Section 41, then we also have Section 40 that allows a contract to be terminated by way of redundancy. Of course, other ways of terminating it would be if, for instance, an employee passes on, the contract automatically comes to an end. So I know that is an area that is quite important, and especially in terms of litigation and when you come to separation. But then, as you said, it's quite a wide scope. So yeah, I could do that as a way of general introduction about the administration of contract and the legal regime in Kenya. Perhaps explain more guided by questions. Thank you.
Beautiful, beautiful. Now, you have mentioned, and I'm seeing questions coming. Let's keep the questions coming. You have talked about discipline. Now, this is one area that today we seem to get it, tomorrow we miss it, you know? Now, talk to us about the disciplinary process. This is very sensitive, Peter, and you know this too well, because you are in law and you are in HR. Please walk us through the process. And I'm hoping that the people in the room, I see the numbers are rising, will pick this step by step. I see a lot of questions in our HR forums. What do I do with this? How do I deal with this? Please walk us through. I know gross misconduct is almost very direct, but there are other disciplinary issues that we need to understand. This is a process. Where do we start? How do we communicate? What do we do? Who sits in the in the committees? Who does what? What letters should we write? Please walk us through it like a fresh HR person.
Yeah, thank you. And I do agree with you as practitioners in the Employment and Labor Relations Court. It is pretty true that most of the cases that would be at the employment or the bar could be about terminations. And it is, maybe I could take a cursory journey about what the law does expect in terms of a fair disciplinary process, especially the one that leads to termination. And like I had indicated, the operating law section of the law is the section 41 of the Employment Act. And if you read it between the lines, it will generally tell you what is expected and what is expected in a fair disciplinary process, and especially separation. And again, paraphrased, it provides that before an employer terminates a contract of employment on the grounds of performance, physical incapacity, or discipline, then the checklist is that they must first of all hear someone, accord them a fair hearing. They must ensure that an employee is represented. They must ensure that the termination is carried out pursuant to a fair disciplinary process. And the same provision of the law falls short of dictating that a fair disciplinary process should have an appeal window. And having said that, the Employment Act does not prescribe the procedure. The procedure is what we can pick from the guidance from the Employment Court in terms of now what will midwife what is deemed to be a fair separation process. And the first aspect that we should always check, the first box you must tick is that you must have grounds. And for this, I'm usually very particular because I've still had many employers who always say that since the contract of employment provides that either party may terminate by giving a 30 days notice, then they take that to mean that provided they have given the notice or they have paid for in lieu of the notice, then they don't see anything wrong. But that is not true. According to the Employment Act, you must have grounds upon which you are terminating that contract of employment. And those grounds, like I've said, are very limited. You're told is either the employee has performance issues, the employee has committed some misconducts. In this case, they may be the normal misconducts or gross misconducts, or the employee is physically unable in what we call termination on the basis of medical grounds. Now, the process, as it were, first of all, you satisfy yourself that you have ground, you have anchored yourself on proper ground, even before you start the process of separation. And here I emphasize that a fair process is a product of grounds, proper grounds, which you are able to substantiate, and then a fair process. So I will start with how do you establish the proper grounds? And as I have highlighted here, maybe let's start with discipline, because the others may have a different trajectory towards a disciplinary hearing. Let's take it that a person, an employee, has breached some regulations, some policies, the code of conduct, name them, which are very clear and which have been brought to them. And they have, maybe for discussion purposes, they have fought at the workplace, or they have been found with an item having stolen from the company. Now, irrespective of irrespective of how the offense has been manifested, let me even say that out of your investigation, they have been captured through CCTV footage, meaning it is in black and white that an employee X was found stealing an item from the employment premises. Still, this employee has a right to be heard, and therefore, the first step would be to have a proper investigation. And here I want to distinguish between an investigation hearing, where now maybe the line manager who the offense has been reported to carries out, and of course, inevitably, it will mean they will have to call this employee and give them an opportunity to explain and maybe respond to statements that may have been written by the security or any other person who perceived the offense being committed firsthand. And the assumption is that the investigation phase would end up with an investigation report. It is this investigation report which, if it shows or it apportions culpability to an employee, that now we will invoke the disciplinary process, which now you'll be writing to the employee directly, and this is what we call a show cause letter, and in essence telling them that from our investigation, it has been established that you did this, or you may have been involved in this and that, which is against either the code of conduct, the Employment Act, policy A or policy B of the company. And therefore, you notify the employee that this employment offense could lead to disciplinary action, depending on whether it is gross, or whether the employee has a history of warning, and especially if it is leading to separation. And here, I need to clarify that Section 41 applies when you are considering separating, meaning it may have been after the journey of the warning letters. I know some companies would have 2 warning letters, others would have 3 warning letters, others would have maybe a verbal and then several warnings. But here, the process, I'm picking it at a point where an employee has either exhausted the warning systems and therefore liable for separation, or where an employee has outrightly committed what is gross misconduct under Section 44. So I'm looking at a process that may lead to separation. So once this show cause is issued to an employee, then they should be given ample time to respond. And here, there is no prescription about what is the adequate time for an employee to respond. You'll find some companies with 24 hours, 48 hours, within 2 weeks, within a week. But there is no magic in the dates, and there is no prescription of the law. It all depends whether it is sufficient for an employee to respond adequately. And of course, it is also a factor of the complexity of what is being investigated. Then the employee will come back with a written explanation that is responding to the investigation report. And if the investigation report is codified, then the employee has a right to that investigation report so that they're able to prepare their defense. Now, depending on whether the employer is satisfied with the explanation from the show cause letter, then it will decide whether it needs to proceed. Assuming you're not satisfied with the reasons or the explanations given in the response to the show cause letter, then you are supposed to convene a meeting where you are supposed to write again to the employee and invite them to a sitting where now they will be able to orally support whatever they would have written and explain. And this is what we call a disciplinary hearing. Depending on the policy of the company, this could be an ad hoc committee. Sometimes it has to be just one person. So, but the whole idea is that they should be accorded ample time to explain themselves. Under Section 41, they have a right to be heard. And in this case, we are talking about them calling an employee of their choice. The law, Section 41, provides of a shop steward or an employee of their choice. And it emphasizes that during the disciplinary hearing, you must, as an employer, listen, capture, and consider what this representative has said. And I've seen this a lot where you find an employer has just looked in the shop stewards of the welfare person or an employee of their choice, but there is absolutely nothing minuted about what they did say during that disciplinary hearing. That doesn't meet the threshold. They are not just supposed to be academic. They are just not supposed to be a flower girl. They are not supposed to just sit in to tick the box. The disciplinary hearing must consider what the shop floor representative or the workers representative has said in response to the allegations against the employee. And once the employee, the hearing has been done and well minuted, then parties should adjourn. Again, in my experience and consultations, I've seen cases where it becomes a real challenge when an employer wants to make a decision after or in the presence of the accused or in the presence of sorry, I'm saying when you want to make it like the disciplinary committee is coming to a consensus to either to separate with an employee, and that almost ends up in disarray because you do not expect a representative to sign into minutes that condemns the employee, and equally you also don't expect the employee to sign on to something that they are agreeing they should be dismissed. So it should end up where you have captured all the presentations and you adjourn and come back with a decision. And these decisions now will come back in a way of a termination. It will come back in a way of a summary dismissal. And if at all it was properly explained, then that decision could end up clearing any allegations against the employer. And now these termination letters should be very detailed. They should refer to the shop cause, should refer to the hearing, and should give a decision about what the decision that has finally been arrived at. And it should always, as a checklist, notify an employee that if at all they are not happy or they are not satisfied about that decision, then they have a right to appeal within a number of days as stipulated in the policies of the company. And if they do appeal, then they will need again another sitting and they will need to be represented again. And then now the outcome of the appeal would be final within the internal disciplinary process. Here, key is that the panel that hears or the office that hears can also not be the office that presides over an appeal. So a disciplinary process should be structured in a way that if, say, the HR is the one who has made a decision, then the appeal should lie in a higher office that has authority to overturn the decisions of the HR. Whether lawyers should present, that is an emerging issue where I've seen it play out in court that the law, of course, says an employee, a shop steward or an employee of your choice. But then assuming an employee shows up with a lawyer or says they want to be represented, then I've seen court cases where it is not cast on stone. You would have to justify what is the prejudice that will be suffered by the company by allowing an employee to be represented by a lawyer. It is always taken that the employer has a higher bargaining power. So if the employee can be able to afford a lawyer, it is deemed that an employer could also be able to bring on a lawyer, and therefore it is a balanced process. You also find it becoming even more lopsided, where the company has internal legal counsel, and therefore an employee feels exposed and they demand that they need to be represented by their lawyer. Now, if you deny them simply on the basis that this lawyer is not an employee, then you'll find that the case takes a wrong turn, and you might find being condemned to pay compensation because that process was not fair. So the key word is fairness, 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 and there is no prescription under the Employment Act. The fairness of each case is dictated by the circumstances therein. And I know in a nutshell, that is the journey from the investigation to the appeal, which sets the end to the internal administrative process. And therefore, the decision of the appeal is final. Esther.
Wow. Wow. I'll go to the questions. I don't know whether anyone would, before I go to the chat, does anyone want to ask a question that far on the disciplinary before we, because I see the questions are mixed. I see data protection. I see different questions. Anyone would want to just unmute? Today is an open mic. You can unmute and make your comment. Okay, let me just go to the questions here. I see Saverius has said, hello panel. I have a question on data protection. Say I'm recruiting and need to conduct a background check on a candidate. Will I need their express permission to contact their previous workplaces? On the other hand, if a recruiter doing a background check reaches out to me to provide work-related info on their prospective candidate, do I still need consent from the said candidate? Peter.
Now, if I got that right, you're asking whether it is okay to carry out a background search on an employee.
Yes.
It is okay, but you need permission. You need to notify this employee that indeed you may contact the referees and they need to give you that consent. Remember, even from the referee perspective, or maybe the previous employer, they would equally to see such permissions before they also give any information about an employee for the risk that they might be sued, and especially if any of it that is given would be classified as personal data under the Data Protection Act. So indeed, you're not allowed to do some discrete background checks, and especially if the same is relied upon to deny someone an opportunity to be employed, then they will have a case against you as an employer, and they have a right. I've seen in cases where they have gone to court seeking that report be made public, that they need to see. If indeed I had been shortlisted and I was just waiting for a letter of offer, and then the same aborted after you did the background, then I need to know whatever you were told and whether it is obviously prejudicial to me, and I have a right to know. So those are the things that you must have in mind, depending on where you are seated. And if you are the previous employer, maybe who somebody is calling you to ask you about the former employee, you may need to ask yourself whether you are assuming an unnecessary risk, because this is the reason you find that under Section 90, all that you're required to give is a certificate of service. All that you're supposed to confirm is that this was my employee in this position from this year to this year, full stop. Anything beyond that is discretionary, and if you use it maybe because you have some maybe ulterior motive and you go and, then that can backfire badly to you. So I don't know whether that is well answered, but yes, generally that's the way it should be.
Wow. Caro, I see your hand is up. Yes. Caro and Kavo, the law in HR. Go ahead. Caro first, then we can go to Kavo. Caroline Minor, your hand is up, right? Okay. The law in HR, Kabo, you can go. Maybe as Caro.
Thank you so much. Mr. Peter, thanks for that elaborate disciplinary process. But maybe I could pick your brain on something which I see HR practitioners, I think they really lose it when it comes to internal disciplinary procedures and a criminal procedure. So maybe Wakili, you could please take us through that, because I normally get a lot of matters and also calls from HR practitioners with regards to internal disciplinary procedures and when to do criminal procedures, and also to initiate both at the same time. So maybe from your experience, you could offer some guidance in that area. Thank you.
Good. Maybe Caro Minor, are you now able to speak?
Can I ask a question?
Yes. Go ahead.
My name is Regina, and my question concerns the disciplinary process. At what point do you give the employee the investigation report, and do you normally give it the way it has been investigated by an independent department apart from HR? Because most of the time it is done by another department, like audit or security department. Do you give it exactly the way it is? There are some parts that you just have to remove from the document. How is that done, and at what point do you give it to an employee?
So Peter.
Thank you. I could start with the second question about the investigation report. And yes, it is, I get where she's coming from, because sometimes the investigation report would have been investigating quite a wide spectrum of offenses and sometimes multiple employees at the same time. So it is not mandatory that you must give everything, including what is not relevant to the employee. It will be sufficient to give excerpts of those areas that are pertinent to the employee in terms of the finding about the culpability, and especially pointing to the evidence, giving the employee all the evidence that have been relied upon to come up to the inference that they should face a disciplinary action. So first of all, again, if you are using that investigation report, whether from internal investigation or external investigation, as a basis for disciplinary action, then, and the employee has a right to know what was investigated and what were the basis of the finding, and that's the way they do a response to that investigative report. So I hope that is answered. About criminal versus the internal administrative process, yes, this has been an area that has been quite hot, and it has seen quite a number of employers find themselves in big problems because of mixing the two. Now, employment disciplinary process, of course, is an administrative process that must be fair, but the burden of required to justify termination is reasonable ground on the balance of probability. So you really do not need to have that evidence that is sufficient for a conviction. And this is why you should not tie the two. You should, assuming an employee has stolen, it would be prudent for you to go through your internal administrative process, dismiss, and then go on and file a complaint at the police, who can now do their own independent investigations. The danger, and I've seen court cases to that effect, is that if you decide to loop in the criminal process, then you're deemed to have incorporated it into your disciplinary process and you'll be bound by the outcome. So it is very risky for you, first of all, to take the employee to police station because then, the police issues could take long. And I'm very sure all of us are very familiar with situations where even these police prosecutions or the criminal prosecutions are brought midway, not because the employee is not culpable, but for many other reasons, including short-circuiting by the prosecutions, including could even bargain out there. So the employer should dissociate themselves completely from criminal sanction. Finish if you have enough grounds to reasonably suspect that this employee committed a certain offense. Use those reasonable grounds that you have within your internal investigation to proceed and separate. Do not wait and do not combine. That would be my take on that. Thank you.
Thank you. Thank you for that. I hope that answers. Yes, good. I see a clap there. In case the contract is for 2 weeks, what will happen with statutory? I think, Mercy, was this statutory deductions or what was it? I assume it should be on a statutory deduction. Yes, yes.
Okay. With regard to statutory, I was meaning about the statutory at the end of the month. Like when it's a check and a share, how will you deduct? And the contract is for 2 weeks.
Okay. So I think you can touch on that, Peter. Yeah, it was statutory deductions. In case you engage someone in a contract for 2 weeks, then how do you handle the statutory deductions?
Yeah, I know that has been quite an issue. But then again, from quite some discipline, if it is a contract shorter than a month, then I've seen many interpretation favor not a monthly wage, but maybe accumulated wage that would be maybe what you'd have been paying on a daily basis. Now, remember, a daily wage, like what we pay on a casual employee, is always higher than monthly wage if you put it together. And the reason it is higher is because it is deemed to incorporate all those benefits that would otherwise this employee who is on a casual doesn't enjoy. But here, ideally, the main catch, yes, or the main catch other than the administration, because if you're having an employee for 2 weeks, then it really doesn't make sense that you have them register with all these bodies and you only need them for a week or two. It actually negates logic. But if you're paying them together, maybe what would have been an accumulation of their daily wages and pay them at the end of the 2 weeks. What is usually key is that you are creating a continuity. You're not creating a situation where you're paying everyone after 24 hours, yet you know that you have a job that could go on for 2 weeks. Remember, there are also other benefits that accrue where you put them on a term contract. Like, for instance, if somebody is, if someone is on a casual basis on a daily, then the law provides that if they work continuously, they'll still be entitled to weekly off days. And now, again, just to use, if you read the Employment Act, you'll find that there is a lot of, even if it is a term contract, you'll find that there are so many other benefits that even if it is a term contract that you don't get unless you're having an extended contract of employment. Like, for instance, if you look at the provisions of sick off, it will provide for a threshold of 2 months. If you look at annual leave, it will provide for a threshold of 2 months. So I wouldn't so much worry about those statutory deductions, of course, unless you're talking about you are paying an amount which would be otherwise also be subjected to taxes, in which case that will still count as an income. So I wouldn't advocate for that hard that I have to do this deduction for an employee you don't need for more than 1 or 2 weeks. But that doesn't mean you cannot have a term contract for 2 weeks. Thank you.
Good. I see Caro is now ready. Caro, you're ready. And after Caro, we can have Mohammed Amin. Then we go back to the chat. And it's 8. I hope that the people on the call are okay if we continue.
Okay, thank you, Esther. Can you hear me?
Yes, we can.
Okay, thank you. I had an issue with my mic. Thank you for your patience. So my question is on disciplinary, most especially warning letters. So does this lie on HR solely, or do head of departments, or rather can head of departments issue out warning letters? My next question is on can head of departments issue out warning letters, or this is solely HR's part, like it's a disciplinary? Yes, so is this solely lying on HR?
Peter, we can allow Mohammed Amin to comment, and then you pick the two. Mohammed, thank you.
Good evening.
Good evening.
My question is on employment contract. Is it a bad labor practice for organizations to be issuing out a fixed term contract of 1 year? Every year they give the same 1 year. Thank you.
Good. I think Peter, sorry.
Sorry,
No,
if I
no.
can add, I've remembered my second question. My second question was when it comes to maybe summary dismissal, that the decision has been made, or you would like to issue a warning letter for a misconduct. Does this lie on HR? Can I, as HR, issue out the warning or the summary dismissal alone? Is this a decision I should make alone, or should I involve senior management? Thank you.
So Peter, you can pick the 3: the warning letters, the 1 year renewable.
Esther, I have a
contract.
question in relation to Mohammed's question. Maybe if you allow
Yes,
me,
that's
I
okay.
can ask.
Peter, I know Peter is writing. That's okay. Yeah.
Okay, in regards to what Mohammed has just asked about the 1 year renewable contract, my question is, if let's say an organization is practicing that whereby employees are given 1 year contract renewable, so in a scenario whereby, say, the employer is not satisfied with an employee's performance and they would love to not renew the contract, is it can the employee take a legal action for the employer for not renewing their contract? And also another question on the same is, how long should an employer give notice to such an employee that we are going to end your contract? Because you find a scenario whereby maybe the managers, or rather the topmost management, will tell you that, okay, this person's contract is coming soon, we are not renewing it. In that scenario, how do you handle it? Thanks.
Good. Peter?
Yeah, thank you for those questions. I'll start with the 1 year. And this is the practice of the company. Is it wrong to give a 1 year renewable? No, it's not. It's provided for by the law. There's always the question of, why are you giving 1 year? Is it because of maybe you are donor funded institution, which is maybe based on a budget 1 year, 1 year. If that is the case, you can give those kind of contracts forever. Is it a regular job and you're just trying to run away from permanency? Then the question would be whether the same amounts to an unfair labor practice under Article 41 of the Constitution of Kenya that provides that every employee has a right to fair labor practice. So it could be legal. There's nothing wrong in giving 1 year, 1 year, 1 year. But then if you're giving 1 year, yet you have a very open-ended job, and maybe you're giving 1 year, 1 year to run away from some obligations that would arise. For instance, if someone is on a permanent basis, then it is likely to be deemed to be an unfair labor practice. And here a good example is that you'd have a company that has the different sets of benefits for permanent and for term contract. Now, this clearly becomes unfair if you decide to have some employees perennially on 1 year contract, so that you defeat the purpose of them being confirmed permanent, so that they are not placed on pensions or medical covers and so on and so forth. But once again, I say there's nothing that prohibits you from planning your business and giving annual contracts as long as does not introduce any form of unfairness. Now again, you cannot introduce 1 year all over, and then all of a sudden you realize the employee is not performing, because now this may be akin to just separating. Because what happens is that you have created what is called a reasonable expectation. And once you create a reasonable expectations that a contract will be renewed, then if you don't renew it, then you still have a duty. You have a duty to tell the employee or to explain to the employee why you have decided not to renew their contract, yet you have renewed for another person. As much as the contract may be within your right to give a 1 year contract, then your practice may easily amount to discrimination and could cause a lot of problems if you do not have an empirical formula or basis upon which you decide which contracts to renew or not to renew. Once again, you should always be ready to establish before the court or any arbiter why you do 1 year for the last 10 years on an employee, as opposed to putting them on an open-ended question. We will always have that big question mark on your end, and unless you have answers, then if you just decide to tell someone, now go home, your contract has come to an end, then definitely that may be deemed to be unfair. Do you need notice? If a contract has a definite beginning and a definite end, then you don't need notice, because the notice is already there. The employee already knows the contract comes to an end on the 31st of December. Fair practice is if you have been renewing it over and over and over, and this year you don't need to renew it, then you need to give notice inside the contract. Yeah, some contracts will actually be very explicit that even a party does not intend to renew the contract, then they should give the other a notice maybe of 1 month or 3 months prior to the expiry of the contract. So if you have got such provisions, then they tie it. And I know you are well versed with the court decisions about this nature of contracts and whether there is any obligation to keep renewing. And the courts have been very clear. Each contract is independent. And if that's what you have signed, then there is no automatic expectation it will be renewed unless, and this is what most of the employers do, unless the employer has given you the expectations. Like, for instance, if you tell an employee that this is a renewable contract, what are you telling this employee? In fact, many will even say it is renewable based on availability of work, based on your performance. So if I am performing and the work is still there and you don't renew, already you will have breached on your promise on me. Whether managers can give warning letters, you should always now mirror this with the with the new act which regulates the HR practice in Kenya, that is the IHRM, and it classifies discipline management as a HR function. So even if you have brought it down to the manager, the HR can never be detached, because discipline management is, and especially when it comes to warning letters that could lead to termination, then that is a disciplinary action that should always be done under the patronage of the HR. And it is not an issue to have managers issue warning letters, maybe depending on the cadre and all that. But such warning letters should always have an appeal, so that if an employee is not satisfied with the warning letter, then they can always appeal, in which case then the HR takes it up to ensure that it's not, it does not midwife an unfairness, or it's not done out of other consideration other than work, discrimination, and sexual harassment and all that. So I would say that HR should always be involved. And whether they make a decision alone, again, that is a factor of the disciplinary procedure. Like you said, there are cases where you have a panel, which is a disciplinary committee that makes a decision, and the HR plays a role of ensuring that the rules of fairness are observed throughout, so that HR communicates the decision of such committee. So it depends on how you are constituted. Now, and here again, and I know different experts may have different scenarios. The role of HR should really not be the one to make the decision. Of course, it's the decision of the company that must be communicated by someone, but you'd want the persons, the people who hear that. And I like where there is a disciplinary panel that is considering the submissions of the employee, and therefore they are the ones who render a decision, and then the HR communicates the same. Thank you.
Good. I'm looking at the questions, and I see like most of them have also been answered. Let me see so that I don't. The law provides that employee facing a disciplinary hearing comes with a representative. What should the employer do if the employee refuses to bring a representative? I think you can put that. The other one for Shadrach, I think yours was answered on contracts. On fixed contract, Edwin, that was answered. What is the risk of having employees on consultancy contracts on paper, but everything else reflects terms of employees on open-ended contracts? So that's the second one. The other one I see you've answered, whether the lawyers are allowed to represent employees during a disciplinary. Yeah, you can answer those two as we screen through the rest. Peter?
Yeah. For consultants, caution should always be made not to mix the two. And as you know, a consultant basically is not an employee, and therefore they are not entitled to the terms stipulated under the Employment Act. So if it is a consultant, it should be strictly be a consultant, and there is not statutory deductions. They are not entitled to the benefits under the Employment Act, be it the weekly off, be it the maternity, be it the working hours, and so on and so forth. So a consultant is paid for the work they do give to the company, like irrespective of the time that they use on it, and therefore that's not an employee, and they don't even pay PAYE. They would be subject to the other taxes, including the withholding taxes. So if you mix the two, then you have a problem. You have a problem with the Employment Act, and you have a problem with the KRA. So let's be clear, it is either a contractor or it's an employee. If it's an employee, you apply the Employment Act fully. If it is a contractor, you exclude the Employment Act and you use the law of contract. That is how distinct it is. So there shouldn't be a hybrid. I don't know whether there was another question there that I haven't taken.
Yeah, I think that's okay. After terminating an employee, does the law provide a fixed time frame when the final dues should be paid? Is there a deadline for paying final dues to a terminated employee? The next one is, if an employee is terminated and not informed that they can appeal, then they appeal and the employer ignores their request for appeal hearing. What is the remedy?
And the second question, where there is no appeal, where you have not notified the employee of an appeal, where the disciplinary process does not have an appeal window, then that disciplinary process is flawed and the outcome of that disciplinary process is unfair. That is the best I can give. That's the most kind words I can have. It is very clear. You didn't give. And in this case, it is even better that despite you giving, the employee has actually appealed and you refuse to listen to it, then you're just handing his employee compensation. A disciplinary procedure that does not have a clear appeal window and an appellate body that has the authority to overturn the decision of the disciplinary committee or the panel, then that disciplinary procedure is flawed and cannot be fair in line with the Employment Act. Terminal dues should be paid promptly. There is absolutely no basis of keeping or holding on to employees' monies after you have separated. And you've seen many cases who now go to court, not because the reasons for termination was not genuine, but because after that they were taken through untold suffering, being told to wait for money. You have terminated someone, but then you're still holding to their money and therefore they can't leave, they can't move on in their life. So it should be prompt. I've seen many CBAs provide for not more than 10 days, but like I've told you, the money is due at the point when you separate with the employee. Thank you.
So good. Rebecca. I see Rebecca requesting for a consent form where the candidate consents for background checks. I know Peter will be sharing his contact. Rebecca, maybe you can reach out to Peter separately.
Hi, Esther.
Hi.
No, I was saying that they can, like, if you are interviewing, you need to share the consent form.
Okay. Oh, to
you need to.
Okay, good.
Yeah. Yes.
Oh, then okay, that's fine. That's fine. Agreed. The other one is, hi panel. What of cases where you are working as a consultancy agent and after setting up the HR system for the client, they decide to terminate the agreement before the agreed duration? How can you go about that? Peter?
Can you get that again?
What of cases where you are working as a consultant and after setting up the HR system, the client decides to terminate the agreement before the agreed duration? How do you handle that?
Yeah, like I said, a consultant is not an employee, and you will find the terms of termination as stipulated in that consultancy agreement. Most of them are terminable with a 30 days notice, but then if you breach a fundamental term, it also provides for immediate termination. Now, if you feel that the termination of that contract was unfair, then your recourse is not the Employment Act, and you don't even have recourse in the Employment and Labor Relations Code. That's the commercial contract that has been breached, and therefore, if you want to sue for breach of contract, that is a civil matter. Thank you.
So you can see Peter. That's why Peter is here.
Sure.
That is where Peter eats. Now, this Puma says, look at this scenario. A person applies for a job and is shortlisted and published publicly. Then a former colleague visits or calls someone in the new organization and badmouths the candidate with rumors or narratives, obstructs and sabotages the candidate's interests. All that unprompted. Isn't that defamation? Peter?
Yeah, it will be defamation if it is untrue. Yeah,
If it
but you
isn't
see,
true.
it can never be defamation if it is indeed true. So if maybe someone has
I think
said
you need
untrue,
to repeat that, Peter.
yeah,
If it's true, it's not
if
defamation.
it is true, it is not defamation. So,
Mhm. Mhm.
but then if indeed someone has said falsehoods against you that has made you suffer damages, maybe reputational or even commercial, then you have a case against them. It may not be employment, that is also civil.
Again, see Peter. If you find time, explain how to handle desertion cases, especially in cases where next of kin contacts are not reachable and the employee is also not reachable. And then I don't know, in such a scenario, do you still do a hearing? Stephanie, by scenario, I mean if you're not renewing or for one reason or the other. I'm lost there, Stephanie, but Peter, you can answer the desertion cases. If you cannot reach the next of kin, how do
Esther,
you?
Esther, can
Yes,
I ask
Nancy?
a question in regards to that desertion so that Peter can at least
Absolutely.
answer?
Yes, yes.
Okay, my question is, let's say during the separation, an employee, of course, one of the requirements is maybe, let's say if in a scenario where you terminate or dismiss, you give the letter and you will inform the employee that final dues will be calculated upon clearance. And then this employee doesn't come to do any clearance. How do you handle that? And if you withhold this salary, is it illegal?
Now, come again on that. This is a deserter. Now, let me get that last part.
There is a deserter who
Yes.
completely does not do the clearance. And also there's a case scenario whereby you've separated with, let's say you've issued a termination letter or this dismissal letter to the employee, no appeal, no clearance, the employee just goes missing. How do you handle this? And should you, let's say, should you decide to hold the salary? Is that termed as illegal?
Okay, a good question. And yes, if an employee who has deserted, if I may use that word, is in essence absent. I'm usually very careful to use desertion and absconding because they have got different meaning under the law. A person who has deserted, it means that you already know that they do not intend to come back. And I know in many cases you do not have that information, given that you're trying to reach them out and you can't find them. So the safest route to proceed is under absenteeism. Now, absenteeism is a ground of gross misconduct, and you need to proceed and terminate that contract on the basis of absenteeism. How you do that? If you cannot reach this person, the court's approach is to see what are the efforts that you did put in place to track and to find and to find this person before you made a decision to ultimately dismiss them on the basis of absenteeism. And yes, you can have a hearing in absentia where you will be documenting all the efforts that you tried to reach out this person, be it calling them on their telephone contacts, their email addresses, they're sending registered mails, which are returned and delivered, so that all that is captured. And having tried all the best, then you can proceed in that committee in absentia and make a decision then to terminate or to dismiss this employee. Now, once you do that, then you're supposed to compute their terminal benefits. And where the employee is unreachable, these terminal benefits should be paid through the labor office. Their certificate of service should be issued, and the dismissal letter should also be issued. So in essence, even in case of terminations, even in cases of desertion, you're still required to follow the due process. And here the danger is where you leave the file open, an employee can always come back with a claim that they were already dismissed. And I've seen so many of those which have gone against the company. The question is, if somebody is absent, why haven't you dismissed them? If they came back tomorrow and claim they were told by the supervisor to go away and never to come back, how will you be able to defend capital? So there shouldn't be a loose file. And perhaps you can reach out to us. We can try to share some of the SOPs for terminating based on desertion, which I know is quite a hot area for many practitioners. Thank you.
Now, Peter, you've reminded me, I was having a conversation with a certain gentleman last week, and he tells me, Esther, I was told to go home, and it's now, is it 2 years? He's never been terminated. His file is open, he's never been called back. That's a juicy case. A very juicy one. The gentleman is still working. Clearly, he should be on payroll. And if he goes to court, he will be paid for all this time. Kavo, I see your hand up. And as you come on, I want to ask Peter to just make this clear. Because I hear a lot of people say, I am holding the final dues because the person has not cleared. Is clearance a legal requirement for an employer to pay final dues, Peter?
Under normal circumstances, yes, if you're told you need to clear, then there's a requirement to cooperate with the company procedures. But where maybe you haven't, for instance, for any reason, say that because you are not reachable, like in the case of desertions and all that, would lack or failure to clear be a reason to withhold employees' terminal benefits? No. You are allowed to offset. What is it that you're claiming from this person? Is it a laptop? Does it have a value? Can you offset? So do not expose yourself to a bigger liability, because if this employee goes to court and says that you have never paid their money for 2 years, that automatically is an unfair case. That case is lost. So, and you will see that somebody, all that they have not taken back is a dashboard worth 200 shillings, and you are holding their gratuity at 200,000 also. Clearly unfair. So finish just the same way we said that even in case of desertion, offset any asset of the company that this person has, then pay the balance. That way, then you can wait for this employee to complain, and if they return, you can pay them the withheld amount. But let's close that file. Remember, if an employee goes to court and any part of their claim succeeds, including them, if they had to use the court to be paid their terminal benefits, then that case has succeeded and you're going to pay the employee's cost. And that is where the Kinyanjuis comes in, because you also pay my cost as well. So do not expose yourself. This is a deserter. You have a clear case of absenteeism, summary dismissal, but you just mess up the case because you held on to someone's benefit, which either denoted that you're still expecting them to come, meaning they were in employment, or maybe because you're doing that to humiliate them, which is an unfair labor practice.
Good. Wakil Kavo, where
Okay, thanks. Thanks for that. Yeah, thanks for that elaborate answer. I'm still on this desertion of the employee. I don't know, Wakili, could you, because there is a case that was, I think in May, June, about desertion, and then they brought up that concept of constructive resignation. I don't know if you could elaborate on that. Thanks.
Perhaps you can give me more details. I'm not very sure I've come across it, or maybe give me what was the gist, what's the relationship between desertion and constructive dismissal?
Okay, no, okay, it's not constructive dismissal.
Yeah.
It's constructive resignation, where the court said that but when an employee deserts employment, as the case has been from this lady who has given us that scenario of desertion, when an employee deserts, they have constructively resignated from their position. So by the employee's conduct, it's like they have withdrawn their contract from they have withdrawn themselves from the contractual relationship. I can't remember the case itself, but they coined up that word, constructive resignation, not dismissal, constructive resignation. It's by the employee's conduct that they have withdrawn themselves from the employer-employee relationship.
Yeah. Thank you for that. And I know many of these cases are usually based on maybe the circumstances of the particular case. And therefore, yes, it is possible that by an employee just leaving and not coming tomorrow, that they may be implied to have resigned. But what is safe for the employer? Do you want that case to come in so that you can interpret it that way, or do you want to take this employee who is not at work, having not notified you in any way that they have resigned? Don't you want to be ahead of the pack and proceed and dismiss? Section 44 allows you to dismiss on absenteeism. So I would be very cautious to wait until this guy goes to court, because now you realize now what is happening is that you're having to discuss, was it a resignation, was it an abscondment, well, what was this? So for me to be safest, I'll tell you, someone is not at work today, has not, maybe they have just received their salary, they have not, you've not seen them again. Allow yourself reasonable time to wait for them. Contact them through the details they provided in their biodata. I saw somebody ask what if they didn't provide. First of all, that is your default as an employer, because the Employment Act is very clear about the details you must have, including the PO box. I think, our Employment Act is still archaic in a way. So it is still telling you should have postal address. So why don't you have it? Because it will be sufficient to just send a registered mail to this PO box supplied by the employee. And if the letter isn't delivered, it is returned and delivered. Then you have the jackpot you need. You have made your efforts. So Wakili, I would say these interpretations are caused by a vacuum. And unfortunately, many other times it could go your way or it could go the employee's way. For me, the safest, I would say, an employee is not at work. It is not lawful leave. There is no permission. They are not reachable. This is a typical case envisaged under Section 44, where you should proceed and dismiss. And that's why I was coming up with that procedure of which is also quite litigated. Wakili, you could also reach. I've shared my email address. You could share those resources, because there are also many cases that actually are very clear that a person who has deserted cannot be deemed to have fired themselves. Employees don't fire themselves. It is you as the employer to fire them. But of course, now with the concept you brought in, if it is resignation, then the employee can resign on their own. And if it is implied that indeed their action amounted to resignation, then they have no right to turn around and sue the employer. Thank you.
Well, I see two hands up. Caro and Wesley, is that in line with what Wakili is speaking about right now? Or we
Yes.
can pick up? Okay.
So mine
Caro.
is on the same. It's on let's say now the employee communicates, they abandoned their duty, no call, no show, and now they've but when you're trying to reach out, that is doing your due diligence as HR, getting to see why are they not coming to work, and they don't pick your calls, next of kin picks the call and tells you that they've not talked for a while because they don't stay together. And now the employee now reaches out through WhatsApp that they're not going to continue being part of the team. Do I still go on with this as a misconduct of abandoning duty, or do I take it up as resignation? Mind you, should I also provide a show cause so that they can explain themselves? This is after giving maybe 7 days of for them to come clean or send a resignation letter. So how do we go about that if they've said through WhatsApp that they're not going to continue being part of the team? Should I go the resignation way, or still it's a misconduct, summary dismissal?
Wesley,
Okay.
maybe Peter, we can
Sure.
listen to. Yes.
I go first.
Wesley. I think there
Okay,
was a hand
Wesley.
up. Wesley. Okay. You can go, Peter.
Where there is communication from an employee that they don't intend to continue working in whatever medium, then that is resignation. And resignation aborts any intended disciplinary action. So if someone has told you clearly that they don't intend to be part of the team, whether through an email, whether through a WhatsApp, or whether through even sending somebody who is able to document the same, then that person has, by their conduct, expressly or impliedly terminated the contract of employment. And therefore, you just proceed and clear them based on the termination clause of their contract. You go disciplinary on the basis of absenteeism. And in this case, they are absconding, where you are saying that this person is not at work and you do not have communication that they are not coming back. You do not have communication that they have since taken up work elsewhere. So this is the typical case of the procedure we are talking about that you now invoke for absconding duty. What is the duration? It is not cast on stone, but again, you should not be trigger happy. You need to show objectivity in the process of trying to look for this person. If you go to court, the court is always looking for goodwill. Is it, what are these efforts to send somebody? Is the time you're talking about even sufficient for you to have posted a letter on post and have it sent with the usual Kenya Post and Telecommunication, because it's a post office box, and maybe reach the other end and then have enough time for somebody to respond? Is it sufficient? So it should not be rushed, and that should be very clearly captured within your procedures. But assuming you're saying like within 3 weeks or 1 month, if somebody you've not heard of the whereabouts of an employee, then you invoke separation on the basis of desertion, then you simply document. So again, just to answer, if you have been notified by an employee through whatever medium that can be documented and proven that they're saying they don't intend to come back to work, then that's a resignation and should be about a disciplinary process.
Great. Hamid asks, when tracking sick off, do we go with calendar days or working days? Number 2, can the scores or performance of candidates previously interviewed be considered in a fresh recruitment of a similar role without necessarily being interviewed again? And I think you can handle that then.
Second question again.
Can the scores or performance of a candidate previously interviewed be considered in a fresh recruitment of a similar role without necessarily being interviewed again? I think this is where you interview the person once, and then instead of calling them again, you can just use the scores of a previous interview to hire the person for a similar role.
I do not see anything wrong. Perhaps you have done a first round and maybe someone was not successful, but you're able to keep their data, and maybe in subsequent recruitment, you can still just use that. I wouldn't say it will do any harm because you've already interviewed them. And yeah, I wouldn't say you need to repeat an academic exercise for a person you've already interviewed.
Good. Then the sick off, when tracking sick off, do we go with calendar days or working days?
When sick offs would be, and I know maybe where this is coming from, like for instance, if someone is continuously unwell, do they break for an off day and then you continue? And it negates logic. Huh? What has I mean, there are different schools of thoughts, but I would say that a sick off is basically not what I would call leave. Assuming, for instance, someone is on leave, and let me maybe take it the way it is in the Employment Act, which I know, despite having been modified by the wages order, still provides for 7 days. So depending on whether it will depend on whether it is continuous, so that if it is within our working hours, then that certainly becomes a working hour. It will be sick off on a working day. But suppose someone is sick on a weekly off day, then you see that sick leave, this person, that off day is subsumed. I mean, they overlap. You cannot later on say that I was unwell when I was on my leave. Because sick off basically allows you to stay away from work because you are unwell. Now, if you're already away, then you're not entitled to sick off. That's why I would still say it is working day. Sick off is when you should have been at work, but due to incapacitation, you're not able to go to work, so you are allowed by a medical doctor.
Good. I think I see several questions on gratuity, so I will read them and then you can just answer them, because it looks like they're the ones remaining. Talk about gratuity pay and how is one qualified. Are employees on short-term contracts or say 3 months entitled to payment of gratuity upon end of contract? I've seen another one just down there. On top of severance pay, do I also pay gratuity? Is it an ongoing practice to pay gratuity? Again, Mercy is also saying if an employee has worked for over 5 years on consecutive one-year renewable contracts, and now they are asking for service pay or gratuity during their exit, should it be calculated based on the entire 5 years of continuous service or only the last contract period? I think generally is on gratuity. Peter, you could answer that.
Yes. Gratuity is not required as a mandatory entitlement under the law. It's actually a creation of policy, a creation of CBA. What is mandatory under the law is the NSSF, and where you are not paying NSSF, then the law obligates you under Section 35 of the Employment Act to pay service pay. So once again, it is not mandatory to pay gratuity, and especially where you pay NSSF, which in any event is statutory. But then again, assume it is your practice to pay gratuity, then such policy will apply. Some of them will say that you earn gratuity after 5 continuous years of service. Others will pay after every complete year of service. They pay a gratuity at the end of the year. And that's why I may not have a straight answer, because you can attach conditions to payment of gratuity. Some of them are contingent on you not being summarily dismissed. And like I said, some of them are contingent upon serving a certain number of years continuously to be entitled to gratuity. So what is important is that you should be consistent in your practice And indeed, if you pay for each complete year of service, even if they were on contract, like someone has been on contract for the last 6 years, and your contract, your gratuity policy provides for each complete year of service, then all those past contracts will count for long-term benefits as long as they are continuous. The keyword is continuous years of service. They are still the same one used to pay severance pay. Again, if someone has been with you for all these years continuously, then severance pay again is attached to continuity for each continuous year of service. Thank you.
So I want us to possibly, well, it's going to 9, it's 45. We can just run through this, Peter. What duration constitutes absconding duty? You can maybe answer that. There's another one here. In a scenario where the company is not doing well financially and employees are agitating for pay rise, and the only way to survive is by separation, by way of redundancy, how do we go about this? So maybe the two, briefly.
Yes, so the
then
second
we can
one,
touch on the others.
redundancy. Yeah, it's quite a process. It's quite a process, which I'm not sure you can exhaust fully with noting the timelines. But yes, if the company is not in a financial position to sustain a certain employee, then section 40 of the Employment Act applies for redundancy, as and you know, it will involve notification to this employee, and if they to the union, you also notify the union and the labor office. So then, of course, you know, there is a principle of the last in, first out that will also apply. And then, you know, the terminal benefits that are prescribed under section 40 that must be paid. That is including the severance pay, the notice pay. And ideally, that's what I'm saying, it's quite a wide, but in a nutshell, I would say that the law allows a company or an employer to get rid of any superfluous workforce if there are proper justification and subject to following the procedures under section 40. So that would generally explain that. Which was the other one? I didn't note it down. The first one, the one you had asked earlier.
Just a minute. Scenario, financially pay redundancy. The other one was the duration that constitutes to absconding of duty.
Yes. Again, it's not a factor of duration. Yeah. Somebody could be away for 2-3 months, but they are still intending to come back to work, only that they are being held by a situation beyond their control. Could be an illness of the parent or somebody close to them. And it is not unusual to find them come after 2 months and they give you plausible ground upon why they were not able to come. So that is not a deserter. So it's not a factor of time. And this is where you told you must make all reasonable efforts to find out why your employee is not back. So the best ground, like I said, is let's not go desertion. Because desertion denotes that you are aware your person will not come. And since you're saying you're trying to reach them and they are not responding and you're sending people and you're making calls and you're calling their next of kin, nobody is coming back with an explanation. And this person is absent. This person hasn't deserted. You don't know that. And I have lost cases in court the hard way. I've learned this the hard way. Don't use desertion and absconding unless you do know that your employee has not come to work and you are aware that they are now driving a neighboring company's truck. That is a typical deserter because you know they don't intend to come back. Where you do not know, then that is an absent employee. Let's go through section 44, make all efforts to reach out to them, then make a deduction that this is unlawful absenteeism, and then proceed and dismiss under section 44.
Good. Thank you, Faith, for the compliment. And Faith asks, what could be the financial implication towards the company for terminating an employee who has been working for more than 10 years, has been absconding duty with reasons such as death, death of close family members with no proof, advice. And then Wesley is, and Wesley wanted to make a comment. I don't know whether this is a comment. One declines to serve termination notice and signing the letter. What are the next steps? So maybe you can comment on those two, the financial implications.
So, you're saying someone has worked for 10 years.
Mm.
They maybe they are saying they have lost someone, a close relative, and they are not able to substantiate. Again, I would say this is typical absenteeism without lawful grounds. This is not absconding. Again, I want to repeat again and again, this is not absconding. If this person, after a few days, a few months, later on comes back to work, that's not an absconder. That's not a deserter. Like again, I've said, a deserter is that person who you know does not intend to come back. That should be within your knowledge as an employer. And that's why you would be writing, if you want to use desertion, I'll be writing to you, Esther, that I am aware that you have since taken up another job with the competition. And therefore, we take it that you have since deserted duty, and we now proceed and separate with you. For this one who is just lying that they lost a close family member and you establish that it is not true, then that becomes an unlawful absenteeism under Section 44. So proceed, take action on this person and dismiss. That is the safest. You already have a ground that is very clear, which is not justified by compassionate basis, it's not justified by permission, it's not justified by illness. So this is the unlawful absenteeism that is envisaged under Section 44, which you should just proceed and dismiss.
Good. The other one was the one who declines to serve termination notice. What are the next steps? And I think we can, I can read the last one as well from Chepkoni. If an employee clears all the full and half days sick pay mid of the year, and she or he has not recovered well, how do you compensate this employee?
Okay, one declines to serve termination notice, your contract is clear. It's either you serve or you pay in lieu. So in this case, where someone has declined, you have a right to recover 1 month's notice from their terminal dues. But of course, unfortunately, if they have none, then that becomes another story. So, but yes, that's what the law provides, that an employee may either serve or pay in lieu. So and if somebody is refusing to sign the letter, you should always make sure that there is additional evidence that indeed this letter was served on them, either by calling a fellow employee, workers representative, a shop steward. Just ensure that you're able to inscribe on that letter that the employee has refused. And the Labour Office is always the best buffer zone. Remember, all terminations must be notified to the Labour Office. So just forward that letter to the Labour Office and clearly indicate that the employee refused to acknowledge it. Either way, it gets effective force, and an employee cannot later on say that they didn't receive. The mischief here is, I will receive to receive it, I refuse to receive it, and later on I will accuse you of having dismissed me already. So always make sure you can consolidate the fact that indeed you served the letter and somebody refused. Now, if an employee clears all the full pay and all the half pay, then the law provides that they are now going to be on unpaid leave. You freeze their salary. You do not terminate them. And that, as you note, sick leave is an annual entitlement. So it will mean for the entire year, they will not be getting their salary. The basic pay would have been frozen, but they're still your employee. Okay. I don't know.
Thank you. I see one more, and I think as we close, wow, it's gone up to 9, but it has been very. I see Faith saying the open mic session has been of help. Thank you. Stephanie is asking, can you surcharge an absent employee if your policy allows instead of directly dismissing them? Also, Stephanie has added, I think, Stephanie, you don't want to be locked out. Also, on failure to renew fixed term contracts at the point of separation, do you do a hearing? So the surcharge one, and yes.
Yeah, can you surcharge an absent employee? I'm not sure what that means, because the law allows you not to pay an employee for the days that they have not worked, and I would not call that surcharge. You simply are not paying for the days that that person has not worked. You don't pay for work not done. So if that was the question, then it is okay not to pay for all those days that an employee has been away. And should you choose to pardon them, then it means they go back to work. It is your discretion as an employer. There's no obligation to pay for a day that someone was absent. And the next question from Stephanie, failure to renew a fixed term contracts at the point of separation. Do you do a hearing? Again, it depends on the wording of your contracts. You will find that in many cases you find that by your own drafting of a contract, you told someone it is renewable unless you are want to. So if you're not renewing, then you're telling me I didn't perform properly. You have a duty to prove that. So that is a typical case of a hearing, because you're taking an administrative action not to renew, and you cannot do that without giving me a hearing. So again, once again, it's basically on how it is worded. And if I would have naturally I naturally was expected to have it renewed, and now you don't want to renew because either you're citing discipline, either you're citing there is no work to be done, or you're citing performance, then you have a duty to explain it to me. Otherwise, I could still sue you, even if not for unfair termination. Remember, there is always this trump card. I could sue you for discrimination. So there is always that danger. You need to be very clear. And if you're making an administrative action that is negative to a Kenyan, then even if not the Employment Act, we still have the Fair Administrative Action Act that still dictates that I have a right to be heard, and I have a right to a fair hearing, and all that. So whatever decision you're making, be it non-renewal, be it termination, it must be fair.
Good. I think Rebecca and Nancy, these are the last ones I will read. Kindly. Grace says, as always, Peter has nailed the session. Well done. Now, Nancy is asking, is surcharge policy a legal practice? And Rebecca is saying, if you terminate an employee on medical grounds, how do you calculate their final dues?
Yeah. On the first one, if you terminate an employee on medical ground, how do you calculate their final dues? This is a normal termination, like I've said, under Section 41. You can terminate on discipline, you can terminate on misconduct, or on physical incapacity. So on medical ground, we actually use retirement on medical ground. And if you are asking what they're entitled to, then they would be their usual. It will depend whether you have gratuities, their days worked. I mean, this is a termination just like any other. The only that is different is summary dismissal, where you say you may not pay the notice, or you may, in some cases, even withhold their accumulated benefits. But for medical ground, remember, it is not punishment. So these employees are entitled to all their benefits. Is surcharge a legal practice? Yes, it is. Under Section 19 of the Employment Act, it allows an employer to do a reasonable surcharge for an employee who either damages or loses the property of the company, or for an employee who is placed in do I say a commercial duty? Do I say a confidential duty? Like, for instance, an employee who is handling petty cash and is not able to account for the entire amount, then you are allowed to surcharge. So the long and short is that it is a legal practice to surcharge within the confines of Section 19 of the Employment Act. Thank you.
Wow. Thank you, Peter. Please tell us where we can find you, as I'm also sharing some links, how you can join our WhatsApp group. We are live on YouTube, so you can watch this over and over again. You can share this with your colleagues. I've shared our LinkedIn page, Esther Katiba. YouTube is Conversations with Esther Katiba. So this is recorded. You can revisit it and you can join our WhatsApp group. So Peter, where do we find you?
Thank you once again.